Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner. With me today is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. Great to be with you.
Good to have you. How was your weekend?
Fantastic. It was good, restful.
Good.
Yeah.
Okay, well, so today we are going to revisit a topic that we spoke about at length in a prior podcast a few weeks ago, and that we've probably talked about every day since the end of June of this year, which is the going into effect of AB 130.
Oh, yeah.
We focused in the prior podcast on the tremendous fallout that I and other competent experts were predicting would result from AB 130, which for those of you who might not be familiar, I would recommend that you go back and listen to the prior podcast episode at HOA Hell and my article on, I've written a couple of articles on it that you can find on the website, mbkchapman.com. But it's the law that went into effect a couple months ago that put a cap on, among many other things, put a cap on HOA fines of $100, basically capped fines at $100. And I have predicted in writing and podcasting the unintended consequences and the fallout for just because of the sheer number of ambiguities and problems with the way that law was written and passed that would far, far, far outstrip and outweigh the one benefit, which is reining in a problem that does exist about excessive fining. And there were so many ways that could have been done. And so what we've seen in the last few weeks in dozens of conversations with potential clients, conversations with clients, conversations with opposing counsel, and conversations with competent counsel on our side is that almost universally, the agreement is this is a terrible law.
Agreed. Absolutely.
Not the concept behind the law, if you were to believe that's what the legislature was really going for.
Yeah.
If the goal was to really help homeowners, then yes, the issue of excessive fines is something that needs to be addressed. But this law was not it. And the only individuals out there right now who are still touting AB 130 as a good thing for California homeowners are the incompetent attorneys who don't understand the law. It's that simple. And I'm declaring that straight out today. I've spoken with some other real estate attorneys who are familiar with Davis Sterling. I've spoken even with a few others who parts of their practice are focused on Davis Sterling, who do what we do, and they agree with us. And there are very few attorneys on the other side, and the ones that are, it's just they're incompetent. There's no way that you could be on the side of AB 130 and actually be in favor of homeowners. It's that simple. So I'm saying it straight out. Okay, but we're going to talk today about how what we've seen just in the last few weeks, and everything I was worried about, and that Sam was worried about, and that we talked about has come to fruition just already, and the press coverage too.
In such a short time, it's all manifesting. I mean,
it's happening now, and it's just going to get worse. Okay, but it's going to be a long time before we know what the courts will say, because it takes a long time to work through our appellate system. So, we're not going to know how the court interprets, which is really the statute, how the court's going to interpret this for a long, long time. So unless the legislature takes a look and revisits this and passes some emergency measures to fix the ambiguities, everything that we're going to talk about today and that we've already talked about, it's just going to get worse. So let's start with that. Sam, what's been your experience?
Well, I will say this. You just touched on it in your introductory remarks, Mike. We are seeing a lot of activity on AB 130 in our PC consultations, meaning potential client consultations. Actual clients, being very inquisitive, very interested. We're having to advise them and guide them through the good and the bad, and mostly the bad, because it turns out to be very disconcerting in terms of their rapid or sudden desire to potentially withdraw or pull back from their own advocacy, relying on AB 130 potentially being a cure-all, and then
relying on AB 130 and what it may or may not say or allow.
Right.
And you're not being specific enough. I want you to get specific.
Not yet. Yeah. No.
I want you to be very specific, okay? Because we have people that have submitted plans, let's say, because they didn't want to, they're good HOA members. They don't want to be fined,
Right.
right? So they submit plans, and now they're thinking of pulling them back and just doing what they want.
Right. Well, 3 quick examples if you want specificity.
Give me some specifics.
We have unapproved front door. And like you alluded to it, we had a process underway where basically we were about to get an approval, by virtue of an agreement. And
you would negotiate.
And it was a fantastic deal. And we're basically
got the client everything they wanted.
At the precipice of getting all of that. And the client mistakenly believed that, look, what if I just give up on this process and pretty much have the whole enforcement action on the HOA side be capped at $100, the cost of doing business, and then tell them to go pound sand. And then in the future, we'll deal with a potential board recall or something to that effect.
Yeah. And when we try to explain, it's not that we don't know about recurring fines or escalating fines or the issue of when you don't fix something, whether you're going to start to have daily fines.
Mm-hmm.
We don't know whether that's going to be, new, if that's considered a new violation.
Correct.
So you might be taking a very big risk doing this because it's not that AB 130 says or doesn't say something. We're not sure.
Right.
And so we can't advise you to do that. You just could come back and bite you really, really badly. But they're relying on some of the things they've heard from some very marketing-minded, actually one in particular marketing-minded attorney who has been touting this as the gift to all the homeowners, and it's just wrong. I mean, that's the attorney that's the one I was talking about. It's wrong.
Right. No, agreed.
And dangerous.
And they, unfortunately, when I say they, I mean the homeowners in this case, whether it's potential clients or active clients of ours or just homeowners in general within HOAs.
Who've written in, even commented on our...
They will see a short headline or a spin, right, intended to kind of play this up by folks who have, perhaps profit oriented motives, and they unfortunately don't have the depth of knowledge or the experience in this area of law to know that there's this unintended blowback effect or consequence, and that's massive. And the uncertainty, I mean, I can't emphasize that word enough. I mean, we lean on very genuinely that there's uncertainty. We don't pretend to know all of the foreseeable outcomes. I mean, it's too soon to tell. Like you said,
we don't know because it's an unknown.
It's an unknown. Right. It needs to be fleshed out through the courts.
I was contacted by a reporter with the San Francisco Chronicle who's doing a big story on this. It's going to come out in the next, I don't know when, but it's going to be published soon. I spoke with her for a better part of 2 hours.
Yeah.
Okay. I haven't read the article. It hasn't come out yet. I have no idea what she's going to say. I know she spoke with lots and lots of attorneys in California, both sides, homeowner side and HOA side. And I know she spoke with attorneys in Central, Southern, and Northern California. And so, but that's just one newspaper. It's a big one for the Bay Area, but we've got LA Times, Long Beach Press Telegram. There's a lot of papers.
There's massive interest.
All right. It's online as well. This has produced a lot of opinions, and you're going to see more and more come out as people jump on the bandwagon. But the consensus is this is a bad law. Not that the goal of we should get a rein on excessive fines isn't a good or laudable goal. It is.
It is.
It's an issue.
Well intentioned, yeah.
But the road to hell is paved with what? Good intentions, man. Right. And this was a badly thought out and badly written law. And it's unfortunate because it's setting people up, the people you were just talking about. These clients of ours or PCs are coming in for advice. Yeah. They're setting them up for a massive failure or fall when we could have, and in your case did, negotiate everything they wanted and already pretty much had it done. Now, don't get us wrong, Sam. The majority of our clients are following our advice.
Yeah, they do.
There's very few that we can't pull off the edge. But the PCs, the potential clients, they're not our clients yet. And they're taking in what we say and then making decisions. So who knows how many of those guys are going off and just doing their own thing. It's a scary proposition. But I have spoken with, we already have. Okay, so let's talk about some of the things I predicted.
Okay, go for
I
it.
predicted that there would be mass confusion, and there is.
There is.
Already, and it's going to get worse. Okay? I predicted that good HOAs, the good ones that are out there, are going to do one of two things. They're either going to be scared to act at all, okay, meaning they'll fine a wrongdoer $100, but not wanting to get engaged in the massive repetitive fining so that they can actually show some teeth to it. because they're scared of being held accountable for something called stacking, which is
Right.
you have let's say you build a balcony without permission. So you have a balcony up, okay? They send you a letter saying, okay, we're calling you in for a hearing. You're found guilty at the hearing for having an illegal balcony. You're fined $100. According to AB 130, it's as much as they can do, right? And then the day after the hearing, balcony's still up. So you just start getting a letter every day and they call you in for a new hearing. They start stacking these. That has been a no-no by the courts for a long time. It's abusive. But it's the only way an HOA, if you think about it, per violation, right?
Yeah.
The only way the HOA could ever get more than $100 out of you is to start sending you a new violation every day. And again, we predicted, we don't know about escalating fines. We don't know about the stacking thing, or about repeat fines or daily fines. It's one violation. You built the balcony once. So that's one violation. I didn't build multiple balconies. I built one balcony. Why isn't that one violation? I don't know.
Yeah.
Okay. And because I don't know, I can't advise. We've had clients ask us, what can I do or not do? And we've had to say,
Right.
I don't know.
We don't know. Yeah.
You came to me the other day during lunch and said, I have a consult with our, one of our clients, and they're asking this question. And, what am I supposed to tell them? And I said, the truth, I don't know. We don't know because we're not the ones that get to interpret the law. And we're seeing it's every day. Okay.
And I'm seeing a lot of attorneys, good attorneys, competent attorneys on the other side of the aisle, whom we've worked with and
we're against.
Adversarial posture.
We're against,
we have resolved cases because they've acted ultimately in good faith, whether it's through mediation or in litigation.
Because they can't help it because we force it.
Right.
Because we're good at what we do.
But they're already, just a couple of months into this, telegraphing that they'll have probably no choice other than to bring more lawsuits.
Which is the next one. So remember, I predicted that good HOAs would either do nothing, they fine you once, and I didn't get to finish that part. So not your fault. You jumped ahead, but that's okay. That's good. But one of the things we predicted was they'll do nothing. They'll try the fine once, and they'll be scared of doing the stacking thing because they don't want to have, they don't want to get sued and have attorney's fees assessed against them. So they will sit back and do nothing, which itself is a violation of the governing documents. And remember, we talked over and over and over and over in multiple episodes of this podcast that one of the fundamental duties of an HOA, in addition to maintaining and repairing, replacing common area, is to enforce the governing documents.
Exactly.
So now you've got a homeowner who, let's say, lives next to the person who built the illegal balcony that's invading, let's say, their view or invading their privacy or whatever. Now the homeowner has a cause of action against the fellow homeowner for building a balcony that violates the rules, and a cause of action against the HOA for not enforcing the governing documents and getting that balcony removed. Right. So what are HOAs going to do? You go to the next thing. They're either going to sit and do nothing, which is going to open them up to lawsuits by our clients, and rightfully so, by the way, or they'll take it into their hands and start filing lawsuits, which is where you were going.
Yeah. And guess what?
We predicted it.
In other case, it leads to massive spending. Right, and fees and special assessments and...
Because insurance, unlike when an HOA gets sued by a homeowner, and then they tender to their insurance covers the defense, right? So they don't have to specially assess all the homeowners to pay for those lawyers throughout that case because insurance is covering it. But when an HOA has to sue to enforce, you don't go to insurance and say, hey, cover my prosecution of this lawsuit against a homeowner for violation.
Right.
Guess who pays for that?
Yeah.
We do. The homeowners.
Or what the point you just made, as far as if HOAs fail to perform one of their fundamental duties, and that is to enforce the governing documents, the point you just made, then guess what? Homeowners have that claim, and guess what? That triggers potentially the D&O coverage on the HOA side, in which case, over time, although it may not be an immediate direct cost or hit against you, insurance goes up. Right. They may not renew you.
Well, that goes without saying. Whenever the more HOAs are sued for wrongdoing, the higher their insurance goes up.
Yeah.
So, but remember, we were talking about just a second ago, we were saying when an HOA is sued by a homeowner for whatever, then they at least can turn to their insurance. So at least in the short time, the members of the HOA aren't going to be especially assessed to cover the lawyer's fees, which could be well into the six figures. But if the HOA is now, to avoid failure to enforce lawsuits, just start filing lawsuits, and to avoid the whole confusion about what can I fine them for, I'm just going to sue them for injunctive relief to take the balcony down. Then I'll get a court order saying, tear your balcony down, and we'll get our fees. That homeowner that has to tear the balcony down pays for the homeowner's defense lawyer, which could be us, right? But also the HOA's lawyers. And so they're going to be on the hook for several $100,000, all because HOAs have lost their ability to actually have a fine structure that has any teeth.
Right.
Because the law was written, the only clear part of the law was maximum $100 per violation. And even that's not clear, because I don't know what per violation means, just based on what we were just talking about.
Right.
But so we've already seen one HOA has already signposted, a big one recently, has already signposted. They're getting ready to, there was an ADR demand coming because they're seeking injunctive relief, and under the Davis-Sterling Act, because that's pretty much all they're seeking,
right.
They have to go through that, they have to attempt mediation first, so they're trying that. They're jumping through that hoop. If the client ultimately says, I'm not tearing my balcony down, you can only fine me $100, which would be a dumb thing to do, but if that's what they do, HOA is going to sue.
Oh, absolutely. 100%.
And that's it's already starting.
Yeah.
It's just started. It's going to happen. Hundreds, thousands, it's going to happen. Hundreds of thousands of times. Hundreds or thousands, not hundreds of thousands.
Right.
Yeah. It's going to happen, and it is happening. We're seeing it. It's just been a few weeks. Just since airing this last podcast, we've seen it, and we've spoken with opposing counsel who are telling us we're not going to have a choice.
Yeah.
Our clients, we're advising our clients to do this. Because of the very things that you and I are now talking about on the phone, and that we've talked about with them. They're going to say, we're going to advise our clients. Like, we get it.
Yeah.
We'll be there. If our clients hire us to defend, we'll defend.
Although many of them stand to benefit from that in terms of the pocketbook, perhaps, because
Well,
they'll
so
get
do we.
more. Exactly. But these are people of good conscience, and they would rather
Some,
right? I mean, the good ones, and they'd rather have some options to really advise their clients of perhaps a sequence of enforcement action steps they can take. But now that's taken off the table.
Here's the thing. Our entire practice is dedicated to representing homeowners. Okay. At MBK Chapman, we do not represent HOAs, period. Okay. And we talk a lot about bad HOAs and abusive HOAs, and that's what our entire practice is focused on. But there are a lot of good HOAs too. And what I mean by good HOAs is there are HOAs that are led by boards of directors of fellow homeowners who actually just want their neighborhoods to run smoothly and who have the best interests in mind and aren't there for the wrong reasons and truly serve. They serve for a few years and then they get off the board and then somebody else comes on, and it's just, it works. There are boards like that, guys, and those boards are what it's supposed to be like, okay? Well, just as there are good HOAs, there are good HOA attorneys that represent HOAs. Now, we've talked about the 10 or 12 in the state. They're the big ones. I would say half of them have some decent lawyers that work for them, and generally we can get along with, and the other half are slime, okay? And the conversations we've had with the good ones, the ones that we respect, have been along the lines that Sam is talking about. And this so we're talking about these predictions, right? We predicted some HOAs are going to do nothing and then face the repercussions of that. We're seeing that happen just a couple times already. And then the flip side of that was some HOAs are just going to start with the litigation process, and they start with an ADR demand because they have to jump through that hoop, and then they're going to proceed. Right. Unless the homeowner says, all right, I give up, and then rips it down. Sure. Then there won't be a lawsuit. What else did we predict? We predicted there was going to be mass confusion.
Oh, yeah.
Over what's allowed, what's not allowed. Well, talk to the reporters who have called. Nobody knows. These reporters have read the statute. Okay, they did their due diligence before they called for opinions, and then they've read articles. So some of the reporters I've spoken with read AB 130, then went and read the few statutes in the Davis-Sterling Act which AB 130 affected, and then went and read articles and came back, and their questions were, okay, so I'm not really understanding what's going to happen with this and what's going to happen with that. And the answer was, good question.
Yeah.
Statute didn't address it. Statute didn't address it. And the legislative notes. Legislative notes are kind of the notes that are taken. It's not binding on a court, but it's very helpful and provides guidance. So if the legislative notes kind of talk about here's kind of what the legislature was going for, and they kind of discussed this issue and said, here's kind of what we're contemplating in the meaning of per violation, right? If it's in the legislative notes, a court can rely on that and say, okay, it's clear what the intent of the legislature was, so I'm going to uphold that. It's silent. on some of the things, some of the big things that we're talking about. There's nothing in the notes.
Well, if the industry professionals, attorneys on both sides of the aisle, the good ones, the competent ones, who have taken
on both sides,
let's just say,
agree this is bad.
Let's just say all. I mean, enough of the qualifiers.
All but like one or two.
If they're confused, if they're broadly confused, and there's so much uncertainty, and that's one thing they can agree on, then guess what? Homeowners and reporters and all of these other folks.
Well, it's not one thing. It's two things.
Two things, yeah.
They're confused, and it's a badly written law, and it's not going to help homeowners. It's also not going to help HOAs. Here's why you have one of those rare occasions where competent, I'm only speaking about competent, okay? Competent lawyers on our side, homeowner side, and competent lawyers on HOA side are in complete agreement that this is bad law and bad for homeowners and bad for HOAs. It's bad for both sides. It's not good for one and bad for the other. It's bad for both. The only, and I said this in my podcast, didn't I? The only people, I'm putting in quotes because I'm going to include HOAs people too, right? The only people who benefit from AB 130 are bad HOAs and bad HOA members. Ones who want to do what they want to do and they don't give a damn about their neighbors. They moved into a neighborhood knowing what the rules were and they don't care. They're going to do it their way because that's what they want to do. Okay? Those are bad HOA members. Right. And then bad HOAs. Why? Bad HOAs are going to do what they want anyway, like they always do. They violate the Davis-Sterling Act left and right. Why is that going to be any different? Okay? Especially when there's ambiguity, they're always going to err on the side of what benefits us, not the homeowner.
Right.
Whereas a good HOA might take a more measured approach. Okay? So bad HOAs are going to benefit because they're going to do what they want anyway. And they're going to, every time there's a way to interpret the statute against the homeowner, they're going to take that and make you spend the money to challenge it. And a lot of people don't have the wherewithal to lay out tens of thousands of dollars to get to the point where a court says bad HOA and then, overturns what they did and then assesses attorney's fees on behalf of the homeowner. It takes a lot to get there, folks. And if you don't have the wherewithal to do that, and they count on that, most people don't, that's what we're going to be at. So bad HOAs. And then bad HOA members are going to benefit from this. Yeah. Because they're going to rely on good HOAs. If a bad HOA member lives in a good HOA, that bad HOA member can get away with, with metaphorical murder and take advantage of the lack of bright line rule here and take advantage of that unknown and intangible factor about we're not sure what we're allowed to do and not allowed to do, and we've been robbed of teeth here, and we don't know how to actually enforce our governing documents. So we're not going to do anything. They're gonna victimize all the good HOA members and have to live with these just outright violations.
And it does really, in those instances that you're referring to, puts the neighbors, the other good members in those HOAs in a precarious place, and it puts the onus on them to have to take action in many cases, on their own dime.
Against both.
Exactly.
Now HOAs are getting sued and homeowners are getting sued.
And that's despite their HOA being perhaps good HOAs and really...
And they don't want to do it.
And it's not like they're disclaiming any responsibility. They just are somewhat confused and they're not sure.
We don't want to err on the side of we're violating the law because we don't want to get nailed.
Yeah.
And we don't trust... Look, I can understand this. We don't trust a court to look strictly at the statute and then send it back to the legislature and say, I, as the court, we're not sure what we're supposed to do. You need to fix this law. Judges are going to do what they want to do. Individual judges will do whatever they want. That's what they do. So they're going to. Okay? Even if it wasn't the original intent, even if it's not in the statute, they're going to say, well, it seems to me this should be it. In the absence of anything, I'm just, this is how I'm ruling. And they'll find a way to make it sound legal and good. That's what courts do. A lot of courts do that. It's the way it is. So what's going to happen is good HOAs are being forced into a position of either having to be aggressive and, again, going and filing lawsuits and taking a risk that they could lose these if they're on the wrong side of it, if the court decides they're on the wrong side, or doing nothing and getting nailed by homeowners who are saying you're failing in your fundamental duty to enforce the governing documents, you're making me do it, and now I'm angry about that, and I'm suing you and the neighbor.
Exactly.
It's happening. It's happening now. We've seen it. Just 2-3 weeks. It's happening. And it's just going to get more and more.
And it's pretty alarming, the pace of how much mess this is already creating. And in the first few, well, it is really weeks, maybe 6 weeks or so, really.
Yeah, basically July 1st, right? So July, August.
Right. Exactly.
And what are we, halfway through August right now?
Yeah, so about 6 weeks, give or take. Yeah. And the mess it's creating and the uncertainty and the confusion.
And it took a week or so just for it to for it to sink
For the
in
word
that
to
it,
get
that
out,
it
yeah.
started. So really, it's been about a month.
Yeah, exactly.
You know, it's crazy. We're everything that I predicted and that Sam predicted and that we talked about is happening, and it starts slow, but it's going to build and build and build. And 6 months from now, I'm sure we're gonna see lawsuits at that point. It's going to take 4 months or so minimum to get through the ADR process, at least the one contemplated by the Davis-Sterling Act. So there's a code section of the Davis-Sterling Act that says if you're suing for injunctive, declaratory, or writ relief, and in this case it would be injunctive and or declaratory relief, but it would be among those, or if you're suing for those in concert with damages of less than $12,500, you have to, before you file that lawsuit, you have to attempt mediation, ADR. But in the context of that statute, they really mean mediation or non-binding arb, which is a waste, so it's mediation, okay?
Yeah.
That's going to take 4 months to get through that process at a minimum. Assuming that everybody goes rapid, it's a minimum of 4 months, because once you make an ADR demand, the other side has 30 days to accept or reject it. If they ignore it, it's deemed a rejection, and then you can go forward with a lawsuit, okay? And then during that 30-day process, if they accept, which most do, if they accept your demand for ADR, then the parties have 90 days, unless they mutually agree to extend that, they have 90 days to complete the ADR process. Well, that's about 4 months. If you take it, if an HOA, let's say, is the one that's being demanded to act, if a homeowner sends an ADR demand, HOA has 30 days. So they wait till the 30th day, they accept. Now it's another 90 days. So that's 4 months. Okay, so at a minimum, we're looking 4 months. So 4 months from now, which will be about almost 6 months from when the law was kicked in, we're going to see a lot more activity. And we'll be able to update you again, and with another podcast, we'll go ahead and update and report that, yep, we're seeing it. It's too soon now, but I think we're good. Based on some conversations we've had with opposing counsel, we're going to start getting in ADR demands, I think.
Yeah. And the one caveat there is unless, and there are some conceivable scenarios where this may happen, you have people currently engaged in ADR mediation or at the precipice of proceeding with that.
Already before.
And they're getting bad counsel. So if they have bad legal counsel and they somehow misinterpret what this means moving forward.
And don't enter into an agreement that otherwise would have been really good for them, like that client we talked about.
Overestimating their position, right? And so that could quickly go sideways.
Yeah, overestimating their position and thinking that the ambiguity actually helps them. Yeah. No, it hurts both. Okay?
Guess what? A lawsuit is around the corner.
Yeah. Ambiguity like this means that neither side knows what's right. That's not a strength in your favor or their favor. It's a weakness in both your favors, or whatever the opposite of favors is.
Against you, yeah.
Against you. If you're relying on, and we've had some PCs ask us, you mentioned in your article something about this will be the cost of doing business. Well, I want it to be that way. I didn't say that's happening. I said that is a potential fallout.
Right.
Some homeowners might treat it that way.
Right.
And if their HOA agrees with that, in that they're scared to act, then there might be the status quo sits there until the homeowner gets sick of it and files a lawsuit. But that's not a win unless it ends that way.
No.
I guess it's a win, but it's really not, because it throws everything up in the air. I mean, the whole point of HOAs, and if you're of the opinion that all HOAs are bad and that nobody should have an HOA, then that's not what this show's really about, because HOAs do serve a purpose.
Yeah.
Okay. A lot of people, including myself, like some of the aspects of an HOA. I just want it done. I just want everybody to go in good faith and live up to what we agree on. And I want the documents to be changeable let the democratic process work itself out. I kind of like that.
Yeah.
I don't like when that is turned on its head and people cheat or lie or manipulate the process to prevent the democratic process. And that's what we fight in our daily practice is bad HOAs. Good HOAs don't do that. They don't subvert the democratic process. When the democratic process is allowed to work, it works. When it is manipulated and turned into a game, because you have people that see their power in an HOA as their own private fiefdoms, or there's a financial incentive for them, or that makes them feel like they have value in their lives, or whatever it is, then you get big problems, and that's why we exist.
Right.
But that's not the ideal, okay?
100%.
So if you believe that HOAs serve a purpose when done correctly, then you're going to see this for what it is, a very bad law that I don't believe was intended to solve a problem that they say it was intended for. I have my opinions on that in my article. I go into that a little bit. But even if it was, If the goal was we've got to fix this problem with excessive fines, great. Then do it competently. This wasn't that. Okay, we could have written this law to accomplish that. If that was the goal, let's get a control on the issue of excessive fines.
Right.
Okay, there's been newspaper. We did a podcast on newspaper story of an HOA in, God, I can't remember where, that started putting up all those video cameras and then started excessively fining everybody.
Oh yeah.
We did a podcast on that. It's an issue, but it could have been solved. This just didn't do it. It doesn't, because there's so many other issues that this is going to cause. Anything else?
I think we've covered quite a bit, given the short span that this is. It's still playing out, but
every day.
Yeah, hopefully our listeners and viewers, get some added clarity from this update. Obviously, I would encourage them to go to your articles. They're very detailed, extensive, and comprehensive. But I mean, this is still playing out, and we're still uncertain as far as the detailed,
right.
next steps.
I can only tell you what I can tell you. And here's the thing. Not everything I said is going to come to fruition. Not everything I said is for example, there was one issue I raised early on in our podcast and in my initial article about the due process issue. Having thought about that more, I'm not sure it's as big a deal as I made it out to be, because I started thinking, it does say in the statute that it does imply the possibility of that agreement being reached after
I see. Yeah.
the hearing, right?
Mm-hmm.
Which means that the homeowner would have a right to get a lawyer, right? But I reacted the way I reacted because it wasn't clear. It was implied, but it wasn't stated. And so I was concerned about that. And because it's such a hot button issue, due process is a big deal. Okay. So, I made it sound like it was a big deal, because it is a big deal if things work out that way. I'm not saying they will. Maybe they won't.
Well, in the aggregate and on balance, there's definitely so much room for abuse. And I think you were predominantly concerned about the bad HOAs and how they could misinterpret
and so far,
abuse.
we haven't seen that come to fruition, but that's also been too soon. So, yeah. Right. So, folks, here's the bottom line, okay? We'll keep you posted on this. Hopefully, the legislature is hearing back from constituents and industry experts on this. I haven't written that letter yet. I'm going to. I doubt anybody will read it, but I'll try. I should probably get that out. But, bottom line is I'm hoping that the legislature revisits this and kind of says, you know what, we kind of left some holes here. Let's try to plug a few so that we can maybe stem some of the stuff that's already started. So we'll keep you posted on this. We're going to do future podcasts. I probably will write a couple of future articles on this. But stay tuned on this, pay attention, because this is still an issue and it's going to play itself out. And so far, with respect to the predictions that Sam and I made in our podcast, I think for the most part, they're coming true so far. So if you like this episode, please hit the like button. And if you haven't already subscribed to our channel, HOA Hell, we'd really appreciate it if you would do that. If you'd like to leave a question or a comment, we read them all. And until next time, folks, have a great day.